Give them as much of the time as possible. Each of them has 15 minutes and not a second more, Peggy said. And then we'll have time left for questions and answers, and we will quit promptly at 5. I think today is just outstanding, and I assume you do too, or you wouldn't still be here at 3:30. And it seems to me it sort of bears the hallmark of what Ed and Ling Chi have done for over 40 years now. And as someone I came down the stairway said, it's great to celebrate, and it's great to celebrate in a way that pushes you forward for the next 40 years.
I didn't want to come behind you, sorry.
We are now complete. So I hope you'll take today, despite some of the afternoon's conversation, as a moment to reflect and to take great pride in what's been done, and to have energy to move it forward. All this stuff takes time, and I've been doing advocacy work after having been a lawyer, and I learned you just go over and over and over, year after year after year. You never quite know when you're going to win, and eventually you do, because you've got the right stuff in the right place at the right time. And so a lot of it is opportunity, or as you were saying this morning, luck, but it's opportunity that is well prepared for in every possible way. And that's what's been happening here since Lao, and I hope will continue. I want to give you the 4 people who are going to speak in the order of their presentations, and I have quite a bit longer bios, but in order to save some time, I'll just give you the highlights. First, to my right, is Ming Chen, who is going to talk to you about language rights. And she's at the University of Colorado Boulder as associate professor, earned her PhD in jurisprudence and social policy at UC Berkeley, and a JD at NYU Law School. And she has done more research on Lao v. Nichols than Ed did to do Lao v. Nichols.
It doesn't take much, unfortunately.
And then my old friend, Henry Hurd. He masquerades as a senior program officer for Freedom's Fund, but really for over 22 years he was the heart of Chinese for affirmative action, and what an extraordinary legacy he has left. He's done work as a teacher and in the Department of Education, and I think the polite way he put it in his bio was that he's part of a group that has supported the building of the building we're in. But my guess is it's a good deal more sinister than that. And then Paul Grossman, who has retired after a brief career at the Office of Civil Rights and the Department of Education for over 40 years, and who will talk to you about disabilities law, which he is still teaching at Hastings. And sometimes I would love to find out, said in his bio that he played the part of Justice Douglas in the mock court that prepared Stanley Pottinger to do the argument. I would just love to know what you said. Finally, Grace Lee, who is now at Chinese for Affirmative Action as their policy director. And she has her GD from UCLA, so I hope Rachel's out of the room by now. And she's going to talk about language access network of San Francisco and much else to do with public service. And with that, Nick, it's yours.
Good afternoon, everybody. Thank you to everyone for having me here, especially our organizers, Ed Simon and Ling Chi. Thank you to Ling Chi, too. Many of you in this room made the civil rights history here through Lao and then taught me about it while I was working on my doctoral dissertation on this subject. And so it's really an honor for me to be here to share back with you my reflections on what many of you did and what many of you taught me in the course of writing this. I think in all seriousness, I've interviewed a good 10 to 20 of you at some point in doing my work. I've read papers from people like Stanley Potterter, who we heard from this morning. And so I really do feel like I'm here as much a student of this history as to teach you anything in my position as a professor. But that said, one of the luxuries of being a professor is that you do have some time to think. And so I'm happy to share those thoughts with you. Well, I think so far today we've already learned so much about Lao, and yet I think there is more that we can be said. As we're moving to the last sessions of the day, it seems like this is an appropriate pivot point to start focusing more on the legacy of Lao, looking forward as well as looking back. And it's been really deeply moving for me to hear from so many of you about what is happening in our classrooms and what is happening as a direct result of Lao. But there's another way, I think, to think about the legacy of Lao, and that is to think about how it's mattered outside of classrooms and how it's mattered outside of the field of education. And so I want to give you a small sampling of what I've learned since studying the Lao case about the ways that it's had a broad impact on a range of policy arenas, which I think together with our panelists might give you another perspective on what Lao meant. So one of the things that's been referred to throughout the day is that Lao versus Nichols really represents several different streams of activism. A lot of that activism happened here in Chinatown, but there was also change that happened through institutional means like the courts and like Congress and like the agencies. And I think that having studied Lao in the context of language rights more broadly, and in particular as compared with other countries, it's important to step back and reflect on the fact that it was a choice that was made to embed the promise of language access in a civil rights framework. And that was a choice that has both limits and opportunities that accompany it. One of the things that it meant is that by anchoring language rights in the Civil Rights Act of 1964 through Title VI, and that language about national origin discrimination being perpetrated without appropriate language accommodations, that on the one hand ensured that it would have a broad reach. Right? Title VI is administered by a whole panoply of federal agencies, and by using that formulation of national origin discrimination, which I think many would say that up until then had been a boilerplate in our civil rights statutes, without people really thinking about or giving content to that meaning, it created an opportunity to give content to national origin discrimination. And in some ways, I think perhaps one of the reasons it was allowed to happen was because people hadn't really been able to figure out what national origin discrimination meant. So it gave at least one concrete meaning that people in power, should they want to do something about it, would be able to do something about. And just to give you a sense of what that meant, I mean, we've been talking about Title VI and its role in public education. The mandate in Lao went on to impact other agencies that similarly administer federal funds under Title VI, so certainly to healthcare and other areas outside of Title VI of the Civil Rights Act. A lot of the logic in the Lao case traveled to Title VII and looking at employment discrimination and the English-only policies that have come up and been challenged using the same national origin discrimination clause. And as well, it's moved to other statutes altogether, including the Voting Rights Act. And I know I have a panelist here who's going to talk a little bit more about voting. But if I could just share one anecdote that I dug up in the annals of the National Archives when I was doing research on the subject. In the Voting Rights Acts of 1975, right, which included amendments that incorporated language provisions, including bilingual ballots, but also including oral translation and other kinds of accommodations for limited English proficient voters. In that legislative record, Lao is directly referenced, which I just thought was stunning to me because, I went to study 3 discrete case studies, and like a good graduate student, I was trying to keep my case studies discrete and separate. And in the midst of studying the record for the Voting Rights Act, I came upon this reference to Lao. And what I found very moving was that the legislators themselves had started to recognize that there was an analogy between what was happening in the classroom and what the court had done with the Lao decision and what it was now incumbent upon them to do with the Voting Rights Act amendments. So in the record, for example, there was a congressman from California who said, if we substitute the word voting for classroom, we can appreciate the difficulties Asian Americans face when they seek to engage in the political process. That's a pretty direct reference to Lao. In another place, I think ultimately, Congress decided that they would move forward with the amendments because they found it patently unfair to require a certain level of literacy from the same minority voters to whom educational opportunities had been denied. After all, many of those language barriers resulted from the unequal educational opportunities that have been afforded to these citizens, right? Citizens who had attended public schools, K through 12, within the United States. And so to me, that recognition shows one of the broad reaches of Lao in moving not only from education to the polls in other areas, but in transforming that sense of expectation so that it became an institutional responsibility and an institutional failure if the language gaps remained after so many years traveling through the classrooms in this country. Another way that I think the implications of Lao can be seen are understanding the ways it was diverted from a judicially administered right to an administratively enforced remedy. And Dean Rachel Moran, who's one of my mentors, I worked for her as a research assistant at some point along the way, talked a lot about this transformation. So I will just focus on one narrow strand of it that we haven't talked about as much. But there's a way in which it has been a rocky path, right? As Lao has moved through the administrative agencies. I think a lot was possible, and a lot was made possible by the choice to move forward with Lao in guidance as opposed to rules and regulations that had gone through the full notice and comment opportunities. But it also created certain vulnerabilities, right, to the courts and legal constraints, such as the cases we've heard about, Castaneda, Sandoval, cases like that, but also to the changing political winds. Right? And if there's anything that I've heard today through this gathering, is that those political winds can turn in your favor, which might have been a lot of what had happened at key moments for Lao, but it can also close against you, right? So you have that opening